You know, there are moments in this country's story where the Supreme Court doesn't just interpret the law, it reminds us who we are, and what happened on June 30th, 2026 was one of those moments. Now, I've been around long enough to understand that not every legal battle changes the direction of a nation. Some do, some don't. But when the highest court in the land votes 6-3 to strike down a sitting president's executive order, an order that would have redefined who gets to be called an American, well, that's not just a legal ruling, that's a constitutional earthquake. And I want to walk you through exactly why this matters, because the details here are going to surprise you. The Blue Bill traced the full legal lineage of this case, one of the few places that'll show you the receipts before asking you to take sides from the 14th Amendment through Wong Kim Ark, all the way to Trump versus Barbara. And when you see how far back this principle goes, you start to understand what was really at stake. Because this wasn't just about immigration policy. This was about whether a president can, with a stroke of a pen on his very first day in office, override 158 years of constitutional law. And the answer the court gave was thundering. But here's the thing most people aren't talking about yet. The dissents. 3 justices disagreed, and what they wrote, that's where the real fight begins. We'll come back to that in a moment. Now look, to understand what just happened, you've got to understand what President Trump was trying to do. On January 20th, 2025, his first day back in office, he signed an executive order attempting to end birthright citizenship for children born in the United States to parents who are either undocumented or here on temporary visas. Think about that for a second. Before the ink was dry on the inaugural address, the first official act was an attempt to rewrite who counts as an American. Now, I respect the office of the presidency. I held it. I know the weight of those decisions, but I also know that executive power has limits, and those limits exist for a reason. The 14th Amendment says it plain as day. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. That language was put there after the Civil War for a reason. The men who wrote it had just fought a war over whether human beings could be treated as property. And they decided deliberately, intentionally, that citizenship would be broad, not narrow, not conditional, not something a president could take away with a memo. And every single lower court that reviewed this executive order agreed. Everyone, federal district judges, 2 appellate circuits, they all said the same thing. One judge called it blatantly unconstitutional. That's not a close call. That's a flashing red light. So, let me walk you through what the Supreme Court actually said, because the reasoning matters as much as the result. Chief Justice John Roberts, and remember this is the conservative justice appointed by George W. Bush, wrote the majority opinion. He was joined by Justice Barrett, another conservative and a Trump appointee, along with all 3 liberal justices, Kagan, Sotomayor, and Jackson. That's 5 votes on constitutional grounds. Now Justice Kavanaugh, also a Trump appointee, agreed with the outcome, but took a different path. He said the executive order didn't violate the 14th Amendment directly, but that it violated federal law, a statute Congress passed in 1940 that codifies birthright citizenship. So even Kavanaugh said the president couldn't do this. That's 6 justices total, telling the White House, no, you cannot redefine American citizenship by executive order. Roberts grounded his opinion in Wong Kim Ark, the landmark 1898 case. A man born in San Francisco to Chinese immigrant parents was denied re-entry to the United States. The court ruled that because he was born on American soil, he was an American citizen. Period. Roberts wrote that the framers of the 14th Amendment extended the promise of citizenship to, quote, every freeborn person in this land. And this is where things start to get complicated because the 3 dissenting justices didn't just disagree. They tried to rewrite the history of the 14th Amendment itself. Justice Thomas wrote a 91-page dissent, 91 pages, arguing that the Citizenship Clause was never meant to cover anyone except freed slaves and their descendants. Let me tell you something about constitutional interpretation. When you spend 91 pages trying to explain why the plain text of an amendment doesn't mean what it says, that tells you something. Justice Gorsuch joined Thomas. Justice Alito wrote separately, calling the majority opinion a serious mistake and raising concerns about birth tourism, women traveling to the United States specifically to give birth so their children gain citizenship. Now, is birth tourism a real phenomenon? Yes. Does it deserve a serious policy conversation? Absolutely. But here's the honest truth. The way to address that is through Congress, through legislation, through the democratic process, not through a president deciding unilaterally to override the Constitution. And that's what Roberts understood. He pointed out that Congress has had over a century and a half to narrow the definition of birthright citizenship. When they wrote the Immigration and Nationality Act in 1952, they could have added a domicile requirement. They didn't. That silence speaks volumes. When the people's representatives choose not to restrict a right over 150 years of lawmaking, a president doesn't get to do it for them with a pen. That's not leadership. That's overreach. And I've learned a few things about the difference between the two. Now, what concerns me, and this is something I think every American should be paying attention to, is what this moment reveals about the state of our institutions. We've got to remember that the system worked here. The courts did their job. Lower courts blocked the order. The Supreme Court affirmed. 6 justices from across the ideological spectrum said, "No, this crosses the line." But the fact that it got this far should worry us. An estimated 255,000 children are born every year to non-citizen parents in the United States. Under this executive order, those children would have been denied citizenship. Some of them might have become stateless, born in America, but citizens of nowhere. Think about what that means for a child. Think about what kind of country does that. And here's what really keeps me up at night. The reaction. President Trump posted on Truth Social, calling the ruling too bad for our country, and immediately called on Congress to legislate an end to birthright citizenship. He said, and I want to be precise here, no long and unwieldy constitutional amendment is necessary. But the majority opinion strongly suggests otherwise. When 6 justices root their decision in the text of the 14th Amendment, you don't get around that with a regular piece of legislation. You need a constitutional amendment which requires 2/3 of both chambers. The president either knows that and is being misleading or doesn't know it. And that's a different kind of problem entirely. Let me tell you why the politics of this matter. Senator Lindsey Graham has already said he'll make ending birthright citizenship a top priority in the Judiciary Committee. Senator Katie Britt has co-sponsored legislation to do exactly that. Vice President Vance called the ruling a major mistake. Now I understand the political incentives. Immigration is an emotional issue. It moves voters, and there are real legitimate concerns about the immigration system that deserve serious attention. But there's a difference between reforming immigration policy and attacking the constitutional foundation of citizenship itself. The Blue Bill laid out the congressional math on this weeks ago. The 2/3 threshold in both chambers makes a constitutional amendment virtually impossible with the current composition. And any legislative workaround would almost certainly face the same fate in the courts. And I think some of the people pushing this know that. Which means this isn't really about changing the law. It's about the message. It's about telling a certain segment of voters that their leaders are fighting for them, even when the fight has no realistic path to victory. That's not governance. That's performance. And the American people deserve better than political theater dressed up as constitutional reform. I spent 8 years in the Oval Office trying to get things done across party lines. Welfare reform, balanced budgets, trade agreements. And the one thing I learned is that when a leader chooses the fight they know they can't win over the compromise that might actually help people, it's the people who lose. So where does this go from here? And this is the part that most people aren't thinking about carefully enough. There are really 3 paths forward. First, the legislative route. Graham and Britt will push their bill. It might get traction in the Senate. Stranger things have happened. But it faces enormous hurdles in the courts even if it passes. The Supreme Court just said the 14th Amendment guarantees this right. Legislation that tries to circumvent an amendment is on shaky constitutional ground, and the justices know it. Kavanaugh left a small door open in his concurrence by suggesting Congress could amend federal statute, but even that's a narrow opening that most legal scholars believe wouldn't survive judicial review after this ruling. Second, the constitutional amendment route. 2/3 of the House, 2/3 of the Senate, ratification by 3/4 of state legislatures. Public opinion polls consistently show that a majority of Americans support birthright citizenship. The NBC News survey around this ruling found 54% say being born here is important to American identity. You're not getting a constitutional amendment through that landscape. Third, and this is the one that worries me most, the slow erosion approach. You don't overturn the ruling. You just make life harder for the people it protects. You create bureaucratic barriers. You challenge documentation. You use executive agencies to drag their feet on processing. That's the quiet route. And in some ways, it's more dangerous than the loud one because it happens without a headline and without a Supreme Court case to stop it. Here's where I come down on all this. I believe in secure borders. I believe in an immigration system that works. I've said that my whole career, and I signed legislation to back it up. But I also believe that when a child is born on American soil, that child is American. That's not a partisan position. That's the position of the United States Constitution, affirmed by a conservative Chief Justice, upheld by 2 Trump-appointed justices, and rooted in a legal tradition that stretches back to English common law and forward through the most transformative amendment in our nation's history. Justice Jackson wrote something in her concurrence that's worth sitting with. She pointed out the deep irony of Justice Thomas arguing that the 14th Amendment, the amendment that guaranteed citizenship to freed slaves, should be read so narrowly that it excludes millions born on American soil. After decades of advocating for a colorblind constitution, Thomas suddenly argued the Citizenship Clause was a race-conscious remedy with limited reach. That contradiction matters because it reveals how these arguments actually work. They start with the answer they want and work backward to find a justification. That's not how constitutional law is supposed to function. The beauty of the 14th Amendment is its breadth. It was written by men who understood that America's definition of citizenship had been too narrow for too long, and they fixed it not with fine print, but with a promise. All persons born in the United States. All that word was chosen for a reason. And this week, the Supreme Court honored that choice. The question now isn't whether this right survives. It already has. The question is whether we as Americans will have the courage to defend the institutions that protect it. Because that's what self-governance demands. Not perfection, not agreement, but a shared commitment to the rules that hold us together. And that, my friends, is worth fighting.